Hello everyone, I'd like to thank Nabil and all the organisers of today's conference, and I'd like to speak on administrative detention. Administrative detention, like internment without trial, is a blunt tool used by oppressive regimes to stifle legitimate political debate, discourage political opposition, and disrupt legal, civil, and societal protests against repressive, coercive, and discriminatory laws, practices, and pogroms. It has been described as the extrajudicial deprivation of liberty by executive action. It is used mainly against innocent, non criminal advocates for peaceful change. If anyone has committed a criminal act, broken a law, or encouraged others by word or deed, they would be brought before a civil court, the evidence presented, and a custodial sentence, where appropriate, handed down. In effect, these emergency powers, which in the United Kingdom have been extended each year, can only be successfully used against citizens against whom no evidence is sufficient for a criminal conviction in a civil court can be applied. By its very nature, these trials are an abomination of the judicial process, an aberration of democratic accountability, and a travesty of injustice visited upon wholly unconvictable members of society. The fact that emergency power laws are used increasingly in the military and non-jury civil courts proves without a shadow of a doubt that these blunt, all-encompassing, all-invasive, and all discriminating pieces of legislation are being utilised to silence the peaceful democratic right to protest, to dissent, and to challenge the illegal military occupations, colonisations, imperialist interventions, and the authoritarian misuse of power. If we look at Ireland, we can see how internment without trial was reintroduced under the Emergency Special Powers Act and used to stifle the civil rights movement in the north of Ireland in 1971. Ostensibly, its use was claimed to be targeted and directed against Republicans who were planning to overthrow the state. In reality, it was a broad, sweeping, field, intelligent-led sweep of general society that arrested many people who had no political agendas and community leaders who voiced the burgeoning call for an end to one-party rule in Northern Ireland and the further democratisation of society, with equality at the forefront of a new beginning between the settler and the native in the north of Ireland. It was invariably the indigenous population, Catholic Irish people, who suffered the ignominy of internment being visited upon them when in 1971 hundreds were carted off to jail having committed no crime. The backlash was fierce, those interned were radicalised, and a new stage of the liberation movement in Ireland was re-energised. In times of war, detention camps have been used to imprison civilians without trial, simply because they have ties with the enemy combatant state, such as the incarcerations of Americans of Japanese descent during World War II. Wholly innocent people detained having committed no crime. The law of innocent until proven guilty, the law of a right to a fair trial, have all been abandoned. In India, the use of the public safety law, used now for over 40 years, allows detention without trial and has been widely exercised against the Muslim majority in India-occupied Kashmir. It is used against women and children too. Human rights groups have claimed that just like in Northern Ireland, detainees have been beaten and brutalised. Innocent people are violently traumatised by the state having transgressed no laws. From Belfast to Srinagar to Jerusalem, people under occupation have faced the brutal reality of life under siege, life under military courts, life under occupation, and life under colonisation. The state can only repress legitimate political challenges through illegitimate special powers and the suspension of civil liberties. I have drawn the parallels between Ireland, Kashmir, and Palestine because the issues are the same, the fight against occupation is the same, and the demand for freedom, sovereignty, and self determination is the same. The Rowland Act was first introduced by the British government in 1919 to counter an Indian anti British uprising, and it was also known as the Black Law. Administrative detention was used under the British mandate in Palestine in 1945 under the Defence Emergency Regulations. As we approach Solidarity with Palestine Day on November 29, I stand with Gaza, I stand with Palestine 48, and I stand with the West Bank. I also stand with the Palestinian diaspora, who we must never forget, and I stand with the prisoners who, just like in Ireland, fight for their rights within a brutal occupation colonial cell. As they thirst and hunger for justice, I remember Kader Adnan, I remember the Irish hunger strikers, I remember those who are on hunger strike today and those murdered in Jerusalem, in Jenin, in Nablus, in Nabi Saleh, but also in Damascus, in Sana'a, in Beirut, in Baghdad, in Khartoum, in Kabul, and Srinagar. In the fight for Palestinians, their prisoners, their leaders, their activists, their politicians, and those who have been martyred, I stand with them all. Where do you stand? Since the year 2000, Adamir, the prisoner advocacy group, has claimed 12,000 Palestinian children have been incarcerated. 81% suffered physical beatings, 86% were subjected to strip searches, 88% did not receive adequate and timely health care, 89% were blindfolded or hooded during detention, 52% were threatened with harm to their families, 47% were denied contact with a lawyer. There are currently 520 persons detained under the administrative detention, internment without trial, without conviction in Israeli jails. In the end, it will not be the brutality of occupation that will hurt us the most, but the silence and abandonment of our friends.